Hello and welcome to Everyday Law. It's the show that demystifies the law for you and your family. I'm your host, Attorney Robert Monahan, and I'm broadcasting from the Magnolia Cafe here at Lamb's Farm. Now, every show I say we demystify the law for you and your family. And I want to talk a little bit about what I mean by that, kind of as a view from 20,000 feet of the show, the purpose of the show. I want you to know by watching this show when you need a lawyer, why you need a lawyer, and what your lawyer is doing for you when he's working for you. Jerry Seinfeld said, "To me, a lawyer is basically the person who knows the rules of the country. We're all throwing the dice, playing the game, moving our pieces around the board, but if there's the problem, the lawyer is the only one who's read the rules on the top of the box." So that's why lawyers are important. We are the ones that have read the rules on the box in this great country of ours where we're moving our pieces around the board. And I would say that you need a lawyer in kind of bigger situations. So to have almost any time money's changing hands, I think it's good to consult a lawyer. Anytime you're dealing with police and prosecutors, it's good to consult a lawyer. Anytime you're dealing with a big life event, it's good to consult a lawyer. The distinction comes that maybe there's some things you can handle yourself, like you don't want to consult a lawyer every time you maybe sign a lease for your family, or sign a credit card agreement, or make an agreement to lease a car. So practical life does intervene, but when the stakes are a little higher, when you have real skin in the game, like when you're buying a house, or when the penalty for making a bad decision or a wrong decision might be jail, or even when your money is changing hands and you have a little bit of negotiating power, I think consulting a lawyer is a good thing. It's almost a necessary thing. And again, the point of the show is to tell you when you need a lawyer, why that is, and what that lawyer does for you. And today we're going to be talking about those things with respect to work on injury cases. Now, I'm an injury attorney, so injury work is what I do, and it's what I love. It's helping people who've been hurt by someone's negligence, someone's bad action. And I almost feel like I'm riding to the rescue, a champion of someone who's been hurt by someone's carelessness or negligence, and I'm there to help them get back on their feet and recover from the person who hurt them. So I see myself as kind of a hero when I do injury work, and I see the other person as the villain. And I especially see their insurance company as the villain because they're trying to not only deny liability if they can, but get out of paying, wriggle out of paying in any way they can. That's my view of the matter. Now, I know most people don't see injury work that way at all. They see injury work as ambulance chasers, people that drive up insurance costs, people that hope to win the lottery, like in that McDonald's case where the woman spilled coffee on herself and got a huge verdict. They drive up insurance costs and basically are brought by greedy people and greedy lawyers. But my opinion about the matter is that those cases, the cases that make the headlines are the outliers, the ordinary cases, the cases where your family member's been hit by a drunk driver, or your grandma's in a nursing home and the nursing staff didn't change the bed sheets and she got terrible bed sores that got infected and led to sepsis. Cases where teenagers may have shot someone intentionally with a BB gun that they should never had in the first place. Those are the kind of cases that have merit, and those are the kind of cases that I really believe in, and those are the kinds of cases I prosecute. And I think personal injury lawyers should feel good about themselves. I think I spent a lot of time in New York City before moving back home to the Midwest. And in New York City, people had a different view of injury lawyers. In the Midwest, I think it's more, I would say people are more skeptical of us, whereas in New York, everyone knew their rights, insisted on their rights, and was loud about it. In the Midwest, people are more salt of the earth, a little more humble, a little less willing to sue someone else. And a lot of times when they come to see me, they come to see me with a lot of hesitation. And I really have to do some work to reassure them that it's okay to bring an injury claim, that it's not the end of the world, that it's not a bad thing, that even good people get injured by people doing bad things. Now, an injury claim basically has two parts. It has fault and damages. So fault means basically that someone did something wrong. And like we talked about before, you only really have a good case if someone did something wrong and that ends up hurting you. And again, that's something you shouldn't feel guilty about, bringing an injury case if someone's been careless and has hurt you. It's something that you're entitled to and you should be compensated for. But again, it starts out with fault. And fault can sometimes be very simple, like a rear-end accident, and sometimes it can be as complicated as multiple cars in an accident where someone had the last clear chance to avoid the accident and didn't take it. One thing that I use to illustrate fault, in fault I mean someone's morally culpable. And there can be kind of a spectrum or a range of this. And notice is a good kind of issue when we're talking about fault. And what I mean by notice is this. Let's say you're visiting a friend in an apartment building. And as you leave your friend's apartment and you go down the stairs, the light in the stairway is out, and you trip down the stairway and fall and you break your arm. Now, fault in that case matters according to how long that light bulb has been out. For example, if it just went out seconds before you entered the staircase, well then it's more like an accident. No one's at fault. No one had notice that there was any problem. But if the light had been out for weeks and people had complained to the landlord about it and the landlord had done nothing, he was on notice and knew there was a problem, the landlord was at fault because he could have done something to help the situation, to prevent the accident, and he ignored it. So he's culpable. He's almost morally culpable, but he's certainly legally culpable if he's on notice of a problem. So that's kind of what fault means in an accident case. Someone has to have done something wrong. And again, the second part is that it led to an injury. And the injury part of the case is generally composed of three elements. The three elements of any injury are your medical bills, your lost wages, and your pain and suffering. Your medical bills are pretty simple. They're whatever it cost you to get treated for your accident. Your lost wages are also pretty simple. They're the time you missed from work because of your injury. They're part of the specials. We call them specials, but they're the hard numbers, a hard figure for your injury, for measuring your damages. The hardest thing to measure would be your pain and suffering, because pain and suffering is not a hard figure. It's kind of a softer figure. And the way you measure pain and suffering is complicated, and there's lots of ways to do it depending upon the accident. But just so you know, every time you see a doctor, the doctor makes a note of your visit. And when he makes a note of your visit, he takes a history, he takes a list of your subjective complaints, he lists subjective tests that he may do on you, and then adds and comments on any diagnostic tests you may have, like x-rays or MRIs. Your pain and suffering can be measured by your subjective complaints that you make to the doctor. He may ask you to rate your pain on a scale of 10, from 1 to 10, so 10 being the worst and 1 being the least pain. During your exercises or during his objective tests, he may find things on palpation and find issues that you may have that show up on his objective findings. And then during the diagnostic tests, he may find objective findings that explain your subjective pain. For example, a spinal injury might be a herniated disc. And a herniated disc is where the intervertebral space between discs has a little puncture in it, and some fluid is leaking out, impinging on a spinal cord, causing pain in your arm or your leg or your neck or your back or your lower back. So the pain and suffering part, so it's not easy to measure. It's a softer number. And it's hard to come up with a good explanation for it sometimes, but what you do is you dive into the medical records, you look at the lost wages and how much time you had to miss because of the injury, and you look at the medical bills to come up with the value of the case. The third question that people always ask me is about who pays your medical bills after an accident. And it's actually a little complicated. Now, the other driver caused your injury, or the other party caused your injury if it's not a car accident. But if it's a car accident, let's just say it is, the other driver caused your injury, and they should pay for all your medical bills. But in reality, it works out a little more complicated than that. The reason is this. A car accident case in Illinois is called a common law case. And the common law case is different than, say, a work injury. In a work injury, it's a pay-as-you-go system. There's an insurance company that your employer has a policy with, and that insurance company, as you get treated, you have your bills submitted to the workers' comp insurance company, and they pay your bills as you go. As you're healing from your workers' comp injury, the insurance company is paying your bills. It's very different in a car accident. In a car accident case, it's not a pay-as-you-go system. The insurance company pays you for your medical bills because your medical bills are part of your injury, but only at the end of the case. That means in the meantime, you have to pay your bills yourself, and that can get very complicated. So you may have several ways to do it. You may have, for example, MedPay insurance as part of your car insurance. Most people don't really understand all that they buy when they buy car insurance, and they know they have property damage insurance if their car gets damaged. They know they have bodily injury insurance if they hurt someone else. But they also have what's called MedPay insurance. And MedPay insurance is a certain amount of money that pays your bills up to a certain limit, sometimes $5,000, sometimes $10,000, sometimes even more, like $25,000. So one source of payment to pay those bills while you're waiting for the other party's insurance to settle the case is your MedPay. Another way of getting your bills paid is through your health insurance. Your health insurance, you could submit your bills to your health insurance, and if you have it, and they could pay your bills. So there's MedPay and there's health insurance. But what if you don't have MedPay? Or what if you've exhausted your MedPay? And what if you don't happen to have health insurance? What if you're one of the unlucky people that doesn't have health insurance coverage? Then you can still get treatment if you can find a doctor who will treat you on what's called a lien basis. A lien is a claim on your settlement. What a lien does is give the doctor or the hospital the right to recover out of your settlement when the case is over for the treatment that they provided you. That is a benefit to you if you don't have health insurance, because the doctor will treat you because they know with the perfected lien they can recover at the end of the case out of your settlement. And that's what a lien is. It's spelled L-I-E-N. And the other thing you should know is that just like the doctor and the hospital that treat you after the accident may have a lien, if your insurance or your MedPay pays your bills, they also have a claim on your settlement. The reason they have a claim on your settlement is because, do you remember how we said that part of your recovery is for your medical bills? You recover that from the third party, the party that hit you, at the end of the case. But if in the meantime your bills have been paid by your health insurance or by your MedPay, and then you recover again from the third party, the party that hit you, you've been paid twice for the same injury. You've been paid twice for the same medical bills. So the insurance companies, the health insurance company and the MedPay company, have a claim on your settlement to be repaid when you recover from the third party. They have what's called a health insurance lien or a MedPay lien. So it can get very confusing who should pay your bills. Ultimately, your bills will get paid, and it's very important to treat after an accident. But so many people worry about paying their bills, and they feel it's unfair that their own health insurance has to pay their bills when another party is responsible for injuring them in the first place. But it all works out in the end. Sometimes you have to rob Peter to pay Paul. Your health insurance pays now, but then they get reimbursed it later. And the beautiful thing about having health insurance is this. When you have health insurance, they pay 20 or 30 cents on the dollar. And when they get paid back, you only pay back the amount that they're out of pocket. So if you have health insurance, you're much better protected if you have an accident than if you don't have health insurance. So we talked a little bit about how your bills get paid. We've talked a little bit about fault and injury in a case. And we talked a little bit about what a lien is and how that works. Another issue that a lot of people wonder about is what happens if the other driver doesn't have sufficient insurance? What if the other driver hits you and doesn't have coverage? Well, Illinois has a law that says everyone has to have a minimum amount of insurance. It's a $20,000, $40,000 policy. That means the minimum one person could, the maximum one person could get is $20,000, and the maximum per accident is $40,000. That's what the 20/40 means. But what if they don't have that, or what if they don't have any insurance at all? They broke the law and didn't buy insurance, or what if your injury is worth more than $20,000? What if you had a surgery on your shoulder and your bills ran to $50,000 to $70,000 for your injury, and the other insurance is not adequate to cover you? What do you do? This is where there's another provision in your insurance policy that we need to talk about. We talked about the common things that people do know about, and we talked about one thing that people don't know about. Everyone knows they have property damage insurance, that if their car gets dinged, they'll have to pay their deductible, take it to the shop, and have it fixed, right? And they pay their deductible, but they have property damage insurance to cover any damage to their car. Most people know they have bodily injury coverage, which means that if they hit someone and cause injury, they're entitled to a defense in the case if they get sued, and their insurance company will pay the other person for their injuries. Also, another thing we talked about was MedPay coverage, where you have coverage up to a certain limit for your medical bills on your own if you're injured in an accident. One thing we didn't talk about, though, was underinsured, uninsured motorist coverage. Underinsured, uninsured motorist coverage. It's called UM/UIM coverage. This is the coverage that kicks in when the other party's injured you and either doesn't have insurance or has too little insurance to cover your injuries. I recommend to everyone that they get as much UM/UIM coverage as possible, because the worst drivers out there are the ones that have the worst insurance, the minimal policies with the carriers that fight you tooth and nail to pay out for your injuries. Anything with American in it is usually bad, like American Access or American Eagle Insurance. Those are usually ones that, those are companies that have minimal, they're called substandard carriers, and they have the minimal limits, and they're for people that have to buy insurance but can't get it any other way. So when you're in an accident, though, often it's too late, and hopefully your insurance agent has told you to get the underinsured, uninsured motorist coverage before you're in an accident, and then you can recover from your own insurance after the accident. And I know a lot of people say, well, why should I go after my own insurance? The other guy hit me, why shouldn't I go after him? Well, he may be able to declare bankruptcy, you may never be able to find him, a judgment against him personally may be totally unenforceable, he may have no assets, and underinsured, uninsured motorist coverage is there to protect you in case you do get hit by someone with bad insurance. And the trick about underinsured, uninsured motorist coverage is this. You may have $100,000 of underinsured motorist coverage. Let's say you do, and you're in a bad accident with someone with poor coverage, and you get a shoulder surgery. After that happens, he will offer up, if your shoulder surgery costs $50,000 to $75,000 and he's at fault, the other carrier will probably offer up their limits pretty quickly, so you'll get the $20,000. So if you have $100,000 of underinsured motorist coverage, you may say, great, I get $120,000 now. But that's where the trick comes in, because there's an offset. In Illinois law, there's an offset for the third party versus your own insurance. The third party is the person that hit you. They offered up their $20,000, so what you're entitled to is really only $80,000. You're entitled to $80,000 of your underinsured motorist coverage because there's an offset for the other driver's first $20,000. So there's a little trick with the underinsured motorist claims. It's really not that bad. I recommend anybody buy as much underinsured, uninsured motorist coverage as they can, because like I said, the worst drivers have the worst insurance. Hi, and welcome back. So now that we've talked about injury and fault, paying your medical bills, underinsured motorist coverage, I wanted to talk a little bit about what an injury attorney actually does for you in your injury case. He assembles everything for you for the first line of defense and then takes it further, okay? So the first line of defense, the first person your injury attorney has to talk to isn't another lawyer, it isn't a jury or a judge, it's an insurance adjuster. And insurance adjusters have hundreds of files on their desk. Their job is to adjust claims and try to dispose of them before incurring legal fees with a lawyer. So the insurance adjuster really is the first audience for your claim. And the job of your injury attorney, at first anyway, before he puts the case in suit, is to prepare the claim to convince the first line of defense, that's the insurance adjuster, that yours is a good claim and that it's valuable. How does he do that? And again, the insurance adjuster, just so you know, has a certain amount of authority that he has as the first line of defense, and that if he wants to go above that authority, he has to go to his manager. So one thing you want to try and discover as an injury attorney is what that adjuster's authority actually is, so we can get beyond that as quickly as possible. But again, what do you do to convince the insurance adjuster that you have a good claim? What your attorney will tell you is your job is to get better. Your job is to treat with your doctor, your physical therapist, whoever your orthopedist, whoever you're seeing for treatment, and then you're seeing your attorney probably while you're still treating, and your attorney's job is to follow the course of your treatment, stay on top of who your doctors are, what your treatment is, how it's going, and what's happening with you and your doctor. But sooner or later, your doctor will tell you, well, you've reached your maximum medical improvement. This is as good as you're going to get. Either you'll be all better, which we all hope, or you'll have something that will last and linger for maybe a while. You'll have something permanent, and your doctor will note that in his records. When your doctor releases you from treatment and says, well, come back as needed, but for now you're done with your physical therapy, you don't need any further injections and so on, then your lawyer comes in and starts to assemble your medical records. But before that, I should say your lawyer is working on your other records as well. So the first thing that your lawyer will do, as soon as you come into his office, as soon as you leave his office, is get the police report. The police report is the paperwork that proves fault. Usually there's a diagram on the police report that shows whether it was a rear-end accident, whether the other driver may have T-boned you, some description of the accident, along with the ticket that was issued to the driver at fault. There's a little citation at the bottom of the police report that says what the citation was for, whether it was following too closely, failure to yield, and so on. And also on the police report, there'll be a list of witnesses that saw it, independent people that can say who did what in the accident, who rear-ended who T-boned who failed to yield, and so on. So the first thing your lawyer will do will get that police report. He'll get that police report, he'll examine it for who was cited, the description of the accident, and who were listed as witnesses to the accident, and then he'll call the witnesses and verify everything on the police report, and if necessary, get statements from the witnesses. Also, one thing your attorney is definitely going to want to do is get photos. Now, we're in the age of the digital camera. The digital photo is ubiquitous, so it's easy to get photos now from any accident. Almost everyone takes photos after they've been in an accident to document. Again, the attorney will prepare your case on fault as soon as he gets the police report. Then the next thing he'll do is get all your medical records and all your medical bills together and put them in a package, okay? He'll review them. And again, we talked earlier in the show about documenting your pain and suffering, documenting your medical bills. He'll send away for any lost wage statement from your employer that you might have so that he can have all the damages together with the medical records, the medical bills, and the lost wage statement. He'll have all of the accident fault information together with the police report, the witness statement, and the photos. And he'll send that off to the adjuster, and the adjuster will start down here. Your attorney for your injury will start up here, and they'll start negotiating, trying to come to some resolution. If they can come to some resolution and meet in the middle, that's very good for you, and you can settle your case and be done with it. If the insurance adjuster stays down here and your attorney stays up here, they may not be able to meet, and the case may have to go before a judge and ultimately before a jury. But again, the first line of defense is that insurance adjuster who tries to adjust your case along with 100 other cases within his authority and dispose of it as quickly as he can. So we've talked about a lot today. The last thing I want to talk about is someone who says, well, geez, couldn't I assemble that package myself and send it off to the adjuster myself? And I have to say that you could, but there are some traps for the unwary you want to be careful of when you do something like that. Do you remember when we talked about liens? Well, when a health provider has a lien on your file, when they have a claim on the settlement because they treated you, whether it's your health insurance company or a doctor or hospital, their name goes on the check unless you negotiate it away first. So I've had people come to see me for cases where they said, well, I settled my case myself, but boy, it has my name and Blue Cross Blue Shield on the check. And Blue Cross Blue Shield, when I called them, they say they have a $40,000 lien and the check is for $50,000. So I just want to say there are some things you should be careful of, and in a personal injury case, it's best to consult a lawyer and not do it yourself because there are traps for the unwary, like liens and so on. So that is why you need a personal injury attorney when you have an accident case. We've talked about when you need it, why you need it, and mainly we've talked about what an injury attorney does for you. He handles the negotiations with the adjuster. He puts together the package. He handles putting together the story on fault and supporting documentation for all the damages. We've also talked about UIM insurance and why you should have it. It's always important to have as much of it as you can. We've talked about who pays your bills. And again, we closed out the show kind of talking about what your attorney does for you, and when you need an attorney, why you need an attorney, and what that attorney does for you. And that's really what I hope to accomplish with this show. Again, we're demystifying the law for you and your family here at Everyday Law. I'm your host, Attorney Robert Monahan. It's a beautiful February day. It's February 27th. It's 60 degrees and sunny outside. I hope everybody enjoys their day, and we get to see a beautiful March. Thanks for listening, and tune in next month for a new show.